Hello and welcome to the Herrington Carmichael Employment Law Update for March 2019. I'm Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got the 4 latest things in employment law for you. And this month it's 4 cases, so bear with me, it might take a little while, but let's try and get through them. So the first case involves Deutsche Bank and a case which is in the European Court of Justice. As many of you know, in the European Court of Justice, the Advocate General gives an opinion on the case before the whole judgment comes out. In this case, it related to working time regulations and whether an employer had to keep actual records of proper working time in order to comply with the Working Time Directive. The Advocate General has said that employers must do that. Now that's going to be quite difficult for some employers to comply with, because actually recording proper working time will be a problem. So we have to see how this comes through in terms of the Working Time Directive when the judgment comes out from the full European Court. Watch this space at this point. Next is the case of Hare, Wines and Core. This case relates to a dismissal at the time of a transfer of undertakings. Now many of you know that where there is a dismissal because of a cheapy transfer, that's automatically unfair unless there is an economic, technical or organisational reason entailing a change in the workforce. However, an employer can also argue that a dismissal was not because of the cheapy transfer to avoid the claim. In this case, the employer tried to argue that Ms. Core was dismissed for personal reasons because of a falling out in the workplace. However, that was not good enough, and it was found that actually the personal reasons would have happened anyway, and actually the real reason was the dismissal because of the transfer. Now, this is a case to watch carefully, because so often in these situations we see employers trying to dismiss employees for a variety of reasons, and when it's close in time to the cheapy transfer, you have to be very careful or have a very good reason. Come and take some advice. The next case, the third case, is Gann-Menachem and de Gruyne. This case relates to a nursery worker who was working in a Jewish nursery, and in this case the individual was cohabiting with her partner, and the nursery came to her and asked her to declare that she wasn't doing that because it didn't fit with the nursery's religious beliefs. The lady in question pursued a religious belief discrimination claim but did not succeed, and the reason she didn't succeed was very close. It was because she was being treated less favourably on grounds of the nursery's religious beliefs and not her own. A very tight line and a very close case, but she did not succeed. If you are involved in religious belief discrimination claims or any discrimination claim, it's important to look very carefully at what the protected characteristic is and what the less favourable treatment relates to. Finally, the case of Spaceman and ISS Mediclean Limited. This case relates to the infringement of a statutory right. In this case, the claimant was dismissed with less than 2 years' service, but he was told at the time of his dismissal that he was going to be dismissed. He tried to argue that was an infringement of a statutory right and he was dismissed because of that infringement. Quite simply, no, it didn't work. It was trying to get around that 2 years' service requirement or 1 year and 51 week requirement in relation to a claim of ordinary unfair dismissal, and he did not succeed. It's a tricky argument for claimants to pursue to try and get around that 1 year and 51 week or 2 year requirement to pursue an ordinary unfair dismissal claim, and this is another case where that has been strictly applied. That's it from me this month. I wish you all a very good March, and I'll be back to you in April. Thank you.